Oh. The Honorable Judges of the Court of Appeals of the State of Alaska. The Court of Appeals is now in session.
Good morning. We are here this morning for the argument in Gomez v. State, file number A13169. Are the parties ready to proceed?
Yes, Your Honor.
Okay, Mr. Horowitz, you may begin.
Well, I guess it's probably not really worth noting, but it was the state's request for oral argument. So I'm sure that they have particular topics that they'll wish to cover that they want to bring to your honor's attention. At this point, I'm not aware what those are. I spent some time reading Wikipedia earlier. What I was looking up was a trial of Sir Walter Raleigh. If we recall, that was explained or cited extensively in Crawford v. Washington by Justice Scalia. The situation with Sir Walter Raleigh was that he was tried for treason, and the primary evidence against him was a signed and sworn confession from his friend and alleged co-conspirator. Raleigh repeatedly requested that that person be called to testify, and he says, quote, "Let my accuser come face to face and be deposed. Were the case but for a small copyhold, you would have witnesses or good proof to lead the jury to a verdict, and I am here for my life." I think that's amazingly applicable to this case. We have a case where if the stakes, maybe not if the stakes were higher, if there were any variation in this case, if there was a different prosecutor, if the facts were slightly different, if the victim was different, just degrees or portions of degrees, you would absolutely expect that the prosecution would 100% of the time bring their chief witness, the complainant, the victim to trial. In this case, they didn't do it. The victim had credibility problems. The victim was reluctant. And rather than present that evidence to the jury, the state apparently voluntarily or strategically decided that they would not present CH, that they would not subject her to direct or cross-examination, and instead relied exclusively on her recorded statements. And the two statements are pretty different in magnitude. You have one, the 911 call, and two, the interview statements, the on-scene interview statements with the officer. I think that the court will very likely subject those to different, well, the same analysis, but could come up with different results as to those two separate statements. As a threshold issue, I think what you need to look at first is whether or not the interview with the officer violates the confrontation clause. If that interview and interrogation with the officer does, you probably don't need to get to the 911 call because the interview with the officer is so much greater in scope, so much more specific in detail, and really was the meat of the evidence or the body of the evidence that led to conviction. The 911 call, of course, was significantly more limited. It did have inculpatory statements in it, but compared to the interview, I think it's relatively minor. Now, the next quote, and I feel like I'm reading on a teleprompter. This is somewhat new to me, so I do appreciate your Honor's patience. But
Can I interrupt for a second? Can we talk about the statement to Officer Mills?
yes, please.
So what's your argument that this was testimonial? There is some indication, I think, in the record that Officer Mills at one point that the victim and the is in a separate apartment by then. And there's some indication in the record that Officer Mills steps out and sees someone being arrested, I think. Maybe you could tell me whether that's before or after this statement. But there's also indications that Officer Mills might not know who the person being handcuffed is. And certainly at the end of this is close in time to the emergency, if not the ongoing emergency. And certainly at the end of the statement to Officer Mills, she's asking whether CH is injured. And so that information is not yet known. So there's some factors that point one way and some factors that point towards it being non-testimonial, some that point towards it being testimonial. So what's your argument with regard to the statement?
I think the answer to that is really the distinction between Davis and Hammond, right? If you look at the fact set in Davis, and they're in the same decision or opinion, which confuses me. The same citation, best I can tell, just different pages. In Davis, you have a situation where there is a call and the reporter or caller or victim is saying, you know, he's jumping on me. He's doing these things in the present tense. And in Hammond, on the other hand, which the Supreme Court found was, I believe they said, an easier call. There was a very similar interview after an alleged offense by an officer with a victim on scene, where victim then gives a sworn statement to the officer or writes down, not a sworn statement, I'm going back to that Walter Raleigh, but writes down what happened. And the officer seems to be conducting the same sort of past tense investigation as he was in this case. Now, I know that the focus is generally on what the declarant is, their mindset, but it's also on the questions asked. And I think if anything, you can use those questions asked as context for the declarations made. And compared to the cases where there's been an injury that needs to be treated, right? Like in, I don't know if it's called Luck or Luke. I mean, you have a absolutely antagonizing case where the woman is dying on the ground from 2 gunshots and the officer is holding her hand. I mean, there's an apparent need for emergency medical treatment. You have the other case, which name escapes me now, where two individuals were hurt and the police were trying to figure out what's going on. Here, in this case, there's no indication that CH was hurt. That you see an evidence gathering mission from the officer here. The questions that the officer is asking are retrospective looking questions about what happened, who did it, tell me more. They're in a she's obviously not relaxed, but this isn't an excited utterance question. It's a testimonial question, even though I still hesitate to concede that. I mean, obviously at one point he says, you know, take some deep breaths towards the end. But whether or not somebody could become re-excited as something goes on, I think is beside the point. He is on an evidence collecting mission. He's asking her what happened for the story, then what happened next, tell me more. And just because it's occasionally interspersed with things like, well, are you hurt? That doesn't change the focus of what he's talking about or what he's asking about. And it also doesn't really change the complainant or CH's perspective at that time. So in terms of whether or not the officer knew exactly when Mr. Gomez was arrested, I don't know the answer to that question. I don't think it matters in particular because he's not collecting evidence to go find Gomez. He's been tasked with interviewing CH, and there are other people on scene that are out there looking for Gomez. His role is really clearly delineated from their role in this situation. And what he's
there's some evidence in the trial court that Officer Mills knew she was assigned somehow to evidence collect, or?
I believe it's just, I could not point to evidence of that. I believe it's just prima facie evident from the way they handled the case here, just based on their testimony at trial. The officer that interviewed CH wasn't running up and down stairs, guns drawn, flashlights on and so forth.
She went out into the hallway when there was somebody being arrested to check to see if it was under control, right?
Okay, and I would agree with that.
When did that happen exactly? When did she go out to the hallway?
You know, I don't have a time signature, and I just
Was it before or during the statements, during the interaction with CH?
I believe it's during. I believe that you can see that it happens during, if I'm correct. If you look at the transcript, I believe there's a break. But at the time that Mills was speaking with CH, there was no indication that Mills was looking for Gomez or was trying to find Gomez. Really.
I mean, Officer Mills knew from CH that there's a knife wielding assailant out there. Why is that not like Michigan v. Bryant, that there's somebody dangerous out there that the police need to figure out whether they remain a danger to the public?
Well, I certainly don't think that's what Mills was.
I guess that's why it really matters. When did she go out? How many things have been said prior to her going out and coming back in? If indeed there's evidence that her going out made it clear that now the situation is resolved, there's no need, there's no ongoing emergency. It actually seems like that factual question seems very important, and you should know the answer to it.
So I would agree that makes it stronger at the point where the officer knows that there is no further danger whatsoever. But regardless of whether or not that makes it stronger, the interview conducted by Mills is still not seeking any of that information. Mills is taking basically a victim statement that you're going to see statement of victim in a police report later down the road. That's what she's getting.
But this is the first time where she gets names of people, correct? At least in the portions that were played at trial. I was a little confused because it sounds like from the judge's ruling that CH maybe gave the names of the suspects later in the 911 call, but that those names were not played, were not part of the assessment of the confrontation clause objection.
That's right. The 911
so she is getting more information during this, and so to the extent there's an ongoing emergency, it seems like that information would be pertinent to resolving that emergency. So the question is there an ongoing emergency still?
So again, I don't know the exact time that Gomez was apprehended or arrested, and perhaps I'll find that for my rebuttal. But that said, whether or not, I think you look at Officer Mills's questions, you look at what Officer Mills is doing, and you see that Officer Mills isn't apparently concerned about an ongoing emergency, that the questions are directed at getting this sort of information that's going to be used at trial. And they're not, where was he last? Where do you think he went? Can you describe the knife? Does he have other weapons? I mean, these weren't the questions that were being asked. They weren't ongoing emergency questions. The questions were about what had happened to CH and details about that. if I'm able, I would like to briefly talk about the prosecution's shifts in this case. And what I had began to quote was, it's in my brief, but it was about these quotes where I was quoting Professor Weston about how the liberal use of hearsay can encourage prosecutors to perhaps be lazy about producing witnesses, or in this case, I don't know, perhaps I'm looking for a kinder word than unscrupulous, but I think that it's fairly clear based on the transcript portions that I cited that the prosecutor in this case had no intention of bringing CH to trial.
Can I ask a question about that? So can you explain your alternate unavailability argument? I think that's what your comments right now are going to. In your brief, you make an argument about CH's unavailability. It seems to me that the question of whether the statements were admissible under the Confrontation Clause rise or fall on whether they were testimonial. And I don't quite follow your unavailability argument. And I also don't think there was an objection below, and you can correct me if I'm wrong, to CH's unavailability or a record created as to what the state did or didn't do to bring her to trial.
Well, I believe that I cited the relevant portions of the trial as to what the state did or didn't do. I don't have, phone logs or anything like that, but they didn't, apparently didn't look.
So Judge Wallenberg's question is, was there an objection? Was there a record made? And I think your answer is no, there was not an objection. There was no record made. And what you did was look at the record as it exists and decided to, and we can draw inferences from it is what you're asking us to do. But that there was no objections, isn't that correct?
The objections about not bringing CH were objections about the burden shifting. They weren't objections about her unavailability as to testimonial evidence or as to hearsay evidence coming in. And that's what I wanted to get into was, and I apologize, Judge Wallenberg, I have to some extent forgotten your question.
Sorry, it was somewhat two parts. And the second part was the question Judge Aller just asked. The first part was, can you explain to us is your argument on CH's unavailability separate from your argument about the testimonial nature of the statement to Officer Mills? And what is that argument?
Well, so again, when I was going towards, or when I was citing the commentary or the treatise from Professor Weston, and then the case law around that, the thought there is that, the Sixth Amendment isn't merely just how to arrange witnesses. There are underlying principles, obviously, and that it led that professor and then the Alaska court citing that work to conclude that, yeah, there has to be some effort made to secure witnesses, that you have to demonstrate the unavailability of them. I mean,
But the case you cite is pre-Crawford. Like, what is the legal framework for your argument?
Well, Crawford changes the analysis in terms of whether or not hearsay exceptions overwhelm, the protection against testimonial evidence guaranteed by the Sixth Amendment. But I would certainly think that that it didn't serve to overrule these other legal principles. Crawford wasn't addressing whether or not somebody actually had to be unavailable. And in that case, the declarant in Crawford was unavailable via marital privilege in Washington or whatever. So these cases, sure, they're long-standing cases and they haven't been overruled. And I think that what they're talking about is certainly relevant to this discussion, where the state didn't subpoena, didn't produce its complaining witness, its victim, and it's Salvador.
So are you arguing that because the state did not produce CH in person, Gomez is entitled to a reversal?
Because they did not produce CH or make efforts at obtaining CH. I mean, if they had been unable to, if she had been really unavailable, then it would be that her outside of the testimonial objections, separate from that consideration, would be that her unavailability would be sufficient to, her unavailability would be a necessary condition of bringing in her out-of-court statements. And so regardless of the testimonial question, before you bring in the out-of-court statements, the witness has to be unavailable. That's never established here.
What is your authority for that, other than in unavailable hearsay exceptions? What is your authority for saying that the witness has to be found to be unavailable before you can bring in non-testimonial?
So that's cited in my brief, and if we give me 1 second here. Working on perhaps too small of a screen to do everything.
Are you talking about stores?
Stores, yes. And so in my brief at pages 21, 22, Stores is the case, quoting confrontation in the hearsay rule. And then the Weston article is confrontation and compulsory process. And those are the authorities. And of course, the treatises aren't any sort of binding authority that I'm citing here.
How does that, I mean, that was, 30 years ago, pre-Crawford. Are you suggesting that there's a different analysis that we should undertake under the Alaska Constitution? And if so, where is that analysis of the Alaska constitutional claim in your brief?
So that I don't believe that because it predates Crawford. I don't think that distinction is. I don't think it affects the determination here that it's pre-Crawford. Crawford is looking at whether Crawford is a bar to testimonial evidence, right? It's just Crawford is saying Sixth Amendment doesn't allow hearsay exceptions to let in testimonial evidence. That violates confrontation. That's its own rule. Prior to that,
I think to see if we're confused about what you're arguing. My understanding of your unavailability argument is that it's an alternative to the testimonial, so that it would be an argument of, okay, well, even if this is non-testimonial, even if it fits for non-testimonial, nevertheless, they're required to show unavailability. Is that in fact what you're arguing? That's what we're confused about, because there's no legal authority for that. But that may not be what you're arguing. Is that what you're actually arguing?
I am,
Okay.
and the authority is what I believe I cited. And what I thought was the interplay between that, or the failure to obtain a witness on the part of the prosecution, the failure to even subpoena the witness, and then to get up and argue that the defense failed to bring in CH, to cross-examine the defense about failing to subpoena CH, and to argue that the defense strategy was just to come in here and attack CH. all interplays greatly with the concerns of those confrontation cases, that what we see is an instance of those flagrant abuses that these courts and the Alaska courts were concerned with occurring. That a prosecutor cannot bring his witness, not subject his witness to cross-examination, not allow the defendant to attack her credibility, which was questionable, and she was reluctant, and then to argue that the defense failed to bring her, that the defense failed to show that she ever recanted. And so it's related, this burden shift that I briefed, it's related to the flagrant issues or flagrant abuses that you see these courts concerned with. And I think what you see is a plan put into place that really skirted the edges of the Sixth Amendment, and it's a problematic conviction. And I'll save the rest of my time if I can.
Can I ask one more question with respect to the closing argument and the problematic portions you're, I think, just referencing? Why wasn't the curative instruction and the related jury instructions regarding the fact that the state bears the burden of proof and always bears the burden of proof sufficient to cure the concerns you mentioned?
Well, these are active arguments by the prosecution. And then the interplay between those instances of burden shifting with the confrontation, I think it's all really, I want to say synergistic. There's an additive effect between what the prosecutor is doing there, and to allow the prosecutor to make the argument that the defense didn't bring in CH and didn't subpoena her. And there's no instruction to the jury that that was improper questioning. There's no instruction that that was improper argument. I recall the pattern instructions, and in some of the instances that I cited, the court denied overruled the objections to what the prosecution was doing. So it pervades the entire trial. And what you see is a conviction based on statements to Officer Mills, and no way for a defendant to challenge those statements, the veracity of the witness, or anything else.
Wasn't the defendant allowed to get into the impeachment issues? They were allowed to introduce evidence about the false confession, about the prior false accusation. Isn't that true?
Well, even if, he doesn't have a person there to question, to confront. And I can't see how there can ever be a substitute in that respect for cross-examination. And I think that's why it's repeatedly held to be as important as it is, notwithstanding the constitutional guarantees, right? The best truth finder or whatever is the crucible of cross-examination. We don't have that here.
But again, no objection, correct? That to the state's failure to bring her as a witness at trial.
Other than as the burden shifting objections, I'm not aware. I can't point to one right now.
Mr. Horowitz, do you want to reserve the rest of your time for rebuttal?
Oh, yes, of course. I thought that was clear. I tried to rest previously and was subjected to more questions. So if there's nothing further,
Ms. Marsh, if you can give Mr. Horowitz back maybe an additional 30 seconds.
thank you, Judge.
Ms. Simel?
There we go. Sorry. May it please the court, my name is Nancy Simel. I represent the state in this matter. Gomez has raised 3 issues in this appeal, and I'd like to focus my remarks today on just one of those issues. Gomez's claim that the admission of an excerpt from the 911 call by CH and an excerpt from Officer Mills's on-the-scene interview with CH violated his confrontation rights. Before we actually get there, there's a few remarks I'd like to make. In Gomez's reply brief, and again today an oral argument, he claims that the state made an intentional decision as a matter of strategy not to call CH at trial, and this supposed strategic decision violated both his confrontation rights, his due process rights, and apparently his compulsory process rights as well. Since arguments cannot be raised for the first time in a reply brief, this court should decline to consider it, especially since it turns on a factual question, whether the state made such a strategic decision. Because Gomez did not raise this claim in the trial court, it was not litigated, and the trial court never made any findings on the question. This court should not impute bad faith to the state based solely on unsubstantiated allegations by defense counsel. In addition, since the claim was raised in less than a page, without any mention of or discussion of legal authority, and without any analysis, this court should deem it waived as inadequately briefed. The state did not concede this in its brief. In footnote 1 on page 8 of the state's brief, it notes that the state was unable to locate CH and that its subpoena was unable to be served. In fact, the very limited evidence available on this point, since it was not litigated in the trial court, suggests the opposite, that the state was making efforts to locate and secure CH's presence at trial, but was willing to proceed without her. A paralegal from the Anchorage DA's office testified about her efforts to locate and contact CH, and that the state subpoena for her was returned unserved. The difficulty the state had in locating CH was to some extent also experienced by the defense. CH apparently told an investigator from the public defender's office that she was avoiding the district attorney's office and avoiding being served. She also indicated that at least one of the many name changes she had undergone was done in part to avoid testifying in this case. Moreover, she was no longer living in Alaska at that time. In any event, whether a statement is testimonial or non-testimonial does not turn on later events. Instead, it turns on the circumstances surrounding the statement and the primary motivation of the person at the time the statement was made. Before getting to that, there's one more thing I would like to address, is that the last claim that this court was discussing with Mr. Horowitz was his claim that unavailability under the Alaska Constitution is a separate requirement for the admissibility of hearsay statements under the Confrontation Clause. And I'd like to emphasize that although Gomez undoubtedly raised a federal constitutional claim, federal confrontation claim in the trial court, he did not raise a state confrontation claim there. But it is not sufficient to raise a state confrontation claim by simply raising a federal constitutional claim, especially when the defendant is asserting that the state confrontation right is broader than the federal right. The record reflects that Gomez did not raise a state confrontation claim in the trial courts. He did not mention it in his in limine motion. nor did he mention it when the motion was argued before the trial court. And the trial court neither addressed it nor entered any ruling on it. Moreover, Gomez has not presented any reason why Alaska's Confrontation Clause should be read more broadly than its federal counterpart. He does not explain why the federal standard of Crawford and later cases is insufficient to satisfy the Alaska Constitution's confrontation provision. When a party claims that a right under the Alaska Constitution should be interpreted differently than its federal counterpart, that party must point to something in the text, history, or context of the Alaska Constitution which justifies this divergent interpretation. Should this court reach the claim, it should reject it. It rejected similar claims with respect to Alaska's confrontation provision in Luke and Shorty, nor am I sure how to pronounce that name as well. Gomez's reliance on stores for the proposition that unavailability is a separate requirement under the state confrontation provision, even when a statement is non-testimonial, is misplaced. Certainly, it's a pre-Crawford case. In addition, as pointed out in the state's brief, stores involved a videotaped deposition. In other words, former testimony. Its application of the unavailability requirement thus was unremarkable. In fact, the unavailability requirement for former testimony is part of Alaska's rules of evidence. Evidence Rule 804b1 sets forth the hearsay exception for former testimony, including depositions, and this rule requires that the declarant be unavailable. More importantly, the court in Storas did not actually reach the confrontation issue. Instead, it decided the case based on Alaska Criminal Rule 15, which conditioned the use of a pretrial deposition at trial on the unavailability of the witness. Thus, Storas does not stand for the broad proposition that under Alaska's Confrontation Clause, unavailability is required before any hearsay evidence may be admitted. Instead, it simply continued to apply the requirement in its traditional context of former testimony. Turning now to the main issue, the state takes the position that there was no violation of Gomez's confrontation rights because the excerpts from CH's 911 call and her interview with Officer Mills were non-testimonial. Before actually discussing that, I'd like to emphasize that only short portions, a very brief portion of the 911 call and a very brief portion of the on-the-scene interview with Officer Mills was introduced at trial. And that needs to be recognized, particularly in response to Mr. Horowitz's argument that the later questions were simply trying to get at what happened. Gomez has argued that the state has hypothesized potential exigencies. He's mistaken. The exigencies involved were neither hypothetical nor potential. In the 911 call, CH's response that a man had just pulled off her pants, held a knife to her neck, and tried to rape her described the nature of the emergency. She had just been subjected to an attempted rape by a man armed with a knife. The fact that it was non-responsive does not alter the nature of the statement. Rather, if anything, it reflects on how distraught she was. The statement explained that the man may still have been armed, wasn't large, and thus could pose a danger to first responders and the public. This information was necessary for the police to safely respond to the situation. CH's statements during the interview with Officer Mills about which man attempted to rape her and which man helped her escape also was necessary for the police to safely and appropriately respond to the situation. There was only a 3-minute interval between the 911 call and the interview. And when the police arrived, both men were still at large and had been fighting outside. And based on my very quick review from what I could tell during this argument, when the officer went outside, it was still in the context of the very beginning portion of that call, based on the citations that I could find.
You mean the beginning portion of her interaction with CH?
Yes.
Okay. So
Yeah.
before the statements that were played at trial, Officer Mills stepped outside and saw.
No.
No. Okay. So I
No.
misunderstood you.
I said the opposite. She had made some of those statements before he went outside.
Okay. But it's not clear where in the interaction the officer stepped
It
outside.
wasn't entire. I don't think she made the statements about the injuries, but I believe she made the statements about the men.
I'm sorry, is Officer Mills a male or female?
You know, I'm not sure from the name.
Yeah, I thought it was female, but then you just said he, so then I thought perhaps not.
Right, I'm not sure. I don't know why I thought it was a he, but the name made me think it was female, but I'm not entirely positive. Her response to the officer's inquiry about whether she had been injured allowed the officer to determine whether she needed immediate medical assistance. CH initially said that she did not know if she had been injured, but she clarified that answer by saying that the man had held a knife to her neck and that she was scared. When is here, a person is distraught and scared and has had a knife pressed to her neck. It is not uncommon that the person might not know whether the knife cut her and caused a physical injury. Movies and books often portray someone looking surprised to see blood in similar types of situations. Such information assisted the officer in assessing the situation and determining what assistance CH needed.
The request about the injuries came toward the very end or not? Of the interaction?
Well, the portion that was played, the interaction was considerably longer than that.
So actually, with respect to the 911 call, that was also considerably longer, correct?
Yes,
And only a portion of it was played at trial.
correct.
And so am I right in recalling that the later portion, the judge indicated that in the later portion of the 911 call that wasn't played at trial, CH did mention the names of the people, of the suspect?
I don't believe that's accurate.
Okay. I was wondering if that was true, and I'm trying to find the place where I thought that was stated, how that would affect the second statement, but you don't think that's correct?
No.
That it's not until the statement to Officer Mills that CH provides the name of, okay.
I think they said, I think if I'm recalling correctly from rereading the transcript, that she said something about the man's brother, but she didn't give the names in the 911 call. Which means that that's not very helpful.
And does the record include the complete 911 call and the complete interview?
Yes, it does.
Oh, here it is. I found it. It's on transcript page 384. I listened to the whole 911 call, and eventually Miss H does give the first names of the individuals, does give a clothing description of the suspect. But then the judge goes on to say there's no indication that Officer Mills would have had as to which of these individuals, it kind of trails off a little bit. Like there's still some kind of question about who the individuals are, but
Right.
But she does provide the names. So how should we factor that into our assessment of the statement to Officer Mills?
Well, I guess my answer to that would be because that portion wasn't played at trial, and that was certainly part of the 911 call, and I think could be is non-testimonial because it addresses the situation again. And I think that the reason that they did it from the on-the-scene interview was because there may have been aspects of that call that were inadmissible for other reasons. And so that information still wasn't presented at trial. Otherwise, there'd be no way, nor was that information communicated to Officer Mills. And at the time he arrived, both men were at large. They could everybody in that apartment could hear Mr. Gomez being arrested. As it turns out, that's who was. And Mills did check outside to see what was going on, and I think that's the reason.
So the names of the suspect, or the name of the suspect and the names of the people involved were not communicated to Officer Mills before she got on the
There's
scene.
no indication of that whatsoever.
And Ms. Amel, who bears the burden here in terms of, is it the state's burden to prove that this is non-testimonial? Is it the defendant's burden to prove that this is testimonial? Where does the burden lie?
Well, I think since the defendant is claiming that it's testimonial, that the burden should lie on him. And I think this is not that close a case where that.
You have authority for that?
No, I do not. I don't believe it's been addressed, to be honest. At least not by this court.
Not by this court, but I think there are other courts that suggest that the state bears the burden of proving non-testimonial is in other jurisdictions.
That may be, and even if the state does, I would submit that in this case, that burden has been more than established. And you take a look at the context of the interview. I guess the last thing I'd like to really say is that the fact that CH was in a different apartment and in police company, and thus she may have been relatively safe, does not render the statement testimonial, because Gomez was still at large, had a knife, and posed a danger to the public. The emergency had not entirely dissipated. And I would state that the setting was informal, extremely informal. It was in the apartment of strangers in the middle of the night, and CH was only partially clothed, and the officer was clearly trying to calm her down. Those factors weigh in favor of a statement being non-testimonial. And I guess I really don't have anything else to say unless the court has further questions.
I have a few questions actually about the issue related to commentary on this defense failure to call witnesses. So from my reading of the cases, there's the usual rule that suggests that you're allowed to make commentary if it's within the exclusive control of the defense. And there's the extension of that usual rule, the broadening of that, that includes what I think various jurisdictions refer to as logical witnesses, meaning witnesses who logically could be presumed to have favorable evidence for the defense, and the defense didn't bring them. But I don't see, at least in my research, there's any place where jurisdictions have adopted anything broader than that rule. And I guess my question to you would be, it would appear to me that neither CH nor Salvador would fit within that category as logical witnesses who could be expected to provide favorable testimony.
That's probably true, but I think here there was evidence that she had never recanted. And given that, I think the rule changes. Regardless, I think that given the instructions of the trial court, given both defense counsel and prosecutors' later comment that the prosecution always bears the burden of proof, that any possible error was harmless beyond a reasonable doubt.
So really more, because I mean, Gilbert kind of sidesteps the issue of was this error and just says harmlessness. And that seems to be kind of the state's approach here too then, is regardless of, you know, what exactly is the rule that Alaska applies, this is harmless because there were so many instances of the state bears the burden, the state is the one who has to call witnesses, that cured whatever impropriety existed.
Right. And this is very similar to Gilbert in the sense that Here, Mr. Gomez did present a number of witnesses on other points, and clearly, and that's very much what happened in Gilbert, and studiously avoided bringing that one witness in. Regardless, as I say, the approach taken in Gilbert was to dodge the issue and conclude it was harmless error at worst.
Are there any more questions?
Thank you.
Okay, thank you, Ms. Samel. Mr. Horowitz?
1 second while I rearrange myself, please.
And did Mr. Horowitz get that 30 seconds that we had originally agreed that he would get?
Yes.
Okay, thank you.
All right, my apologies. Trying to work from my home rather than my office. So one of the questions that was asked was, why don't the curative instructions fix the burden shifting? Why don't the normal instructions that are given to the jury in all trials fix the burden shifting? And what I wanted to point to was at pages 25 and 26 of my brief. I'm citing transcript pages 1388 to 89. This is where the prosecutor is arguing in closing that the jury should consider CH's non-appearance and lack of testimony as evidence of Gomez's guilt. And that's where Gomez objected and was overruled. And now I have to admit to a bit of a typographical error at the bottom of the block quote at the beginning of the next page. So Gomez objects. The defense says objection. He's shifting the burden. He's telling him to focus on our case and what we didn't say. We don't have to say anything. The fact that we didn't say anything doesn't mean he gets to say you didn't hear this. That's burden shift. And the court answers no. You can make a reasonable comment on the evidence. The defense argues, well, he can make a reasonable comment on the evidence, but he doesn't get to say, think about the fact that you didn't hear that. That's burden shifting. And at the end of that, I wrote that the defense says, and you're entitled to do that. He can do that. That's my typographical error. That's the court. The court there says, and you're entitled to do that. He can do that. So
Where are you? I'm sorry, what page?
So my brief, page 26, block quote at the top.
I don't have a block quote at the top. You're just talking about the dialogue?
Yes,
Okay. Oh, so the,
Who
okay.
identified as defense was actually the court.
correct. The last statement is actually the court.
Oh, I see.
So I double checked that. That was an error on my part. And so that's the court's answer. That's the court's instruction. All right. That's what the jury, I suppose, hears, that the prosecution is allowed to do that. And so to the extent that there's inconsistent instruction given, I don't know why the court would.
Mr. Horowitz, where is that argument? Your argument on this starts on the bottom of 27 and lasts a few sentences and ends at the top of 28.
My argument
Your
about
argument that this is error, right? Because then on page 28, you go into these errors were not harmless. How is that adequate to preserve the arguments you're making now?
Okay, so on 23, I talk about how the burden is shifting. I cite the law on that, and I point out where the burden shifts on 24 and 25 and 26, and I'm showing you. And then I go on to the burden shifting is inappropriate on 27 and 28, and then I explain that the errors were not harmless. I mean, I don't know. I think I sufficiently briefed it over several pages. I can appreciate that it could have been longer, but all the elements of the argument are there from pages 23 to 28.
Well, I view 24 to 27 as essentially a recitation of the facts and the argument about whether those facts constituted error starts at the bottom of 27. Am I reading that incorrectly?
I mean, I'm not going to try to argue your reading of it. I mean, certainly. I mean,
I think probably what
that
Judge
said,
Wallenberg, if you
if-
can respond to, I think what Judge Wallenberg is somewhat responding to is the state briefed actually this issue in the actual legal framework of Gilbert and Lewis and McCurry, and your brief doesn't, and then you don't come back to it in reply at all. So maybe you can respond to the state's points now about their argument that this is very similar to Gilbert, and that notwithstanding that there are limits to when a prosecutor may make comments about a defense failure to call a witness, it's not so black and white as they can never do it. They can, certainly under the usual rule, when it's exclusive control, or also if it's a logical witness, and then why this then does not fall into those categories, and why there's not enough curative statements about how the state bears all the burden of calling witnesses.
Well, sure, Your Honor, and I think that a lot of those questions speak for themselves in this case. I mean, what you're dealing with is a complainant, the alleged victim, that's absent. I mean, to hold otherwise on that fact or that question alone would require a defendant to subpoena his alleged victim into court, which just certainly would not be a logical witness for him to call. And so under that framework, you wouldn't expect him. He would not have the burden of subpoenaing and bringing the victim. And the state would not be allowed to comment on his failure to bring in the victim. It's the state's victim that's alleging the crime that they failed to bring in. And from the get-go, when questioned about whether they were going to bring her, responded with what I read as coy answers, saying, his answers to that question was, I don't think she's essential. I don't think I need to bring her in. That was the plan that was in operation for a long time before the trial. And you see the paralegal testifying that I cited to.
It's your past time, if you can just take a minute to wrap up.
So it was a year and a half that paralegal had no attempted communication with the victim. And the person that does the service said he didn't even recognize the name. That's where I come up with nobody tried. And I think it was apparent that nobody tried from the record that I presented and was established at trial. I certainly think that we enter a difficult period of our jurisprudence when we allow the prosecutor to not bring witnesses, to play their recorded statements, and then to blame their non-appearance on the defense. Thank you.
Thank you, Mr. Horowitz. So thank you, counsel. We will take this matter under advisement, and we stand in recess.